Imagine a tiny house that breaks the law 5 separate times before you even open the front door. Registered as a vehicle, but never moved once. Sitting on land zoned for something else entirely. Built to a square footage the county says isn't a legal dwelling. Wired with a second kitchen nobody ever permitted. And connected to utilities that were never inspected or signed off on. No single one of those things would make headlines on its own. Put all 5 together in one 400 square foot structure, and you've got something that isn't just borderline. It's a genuine legal house of cards. One inspection away from collapsing entirely. This isn't a hypothetical horror story. Every single violation I just listed is something that's actually happened to real tiny houses in real enforcement cases across the country and around the world in the last 2 years. In this video, I'm building the complete picture. The most legally compromised tiny house that could plausibly exist, based entirely on real, documented violation types, and showing you exactly how each layer of illegality stacks on top of the last. By the end, you're going to understand exactly what illegal actually means for a tiny house, why it's rarely just one broken rule, and how to make sure your own tiny house never ends up looking anything like this one. Before we start stacking violations, hit subscribe now, because I'm going to walk through this layer by layer from the ground up, and the final violation on this list is the one that actually gets tiny houses shut down fastest in 2026. Subscribe now so you don't miss it. Let's start with the foundation this whole thing sits on, literally. Here's something most people don't realize until they're already deep into owning a tiny house. There isn't one single law that determines whether your home is legal. There are several separate legal systems stacked on top of each other, and a tiny house can violate any combination of them independently. The first layer is classification. A tiny house on wheels is legally treated as a vehicle in most of the country. Personal property, registered through the DMV, not real estate. That classification comes with an implicit condition. The house is supposed to actually behave like a movable structure. The moment it stops moving for an extended period, gets permanently skirted, and gets connected to permanent utility hookups, it starts looking, functionally, like a permanent dwelling, even though its paperwork still says vehicle. This is exactly the mechanism behind one of the most common ways tiny houses drift into illegal territory without their owners realizing it. Current 2026 zoning guides are blunt about the consequence. Ignore your local classification rules, and you could be forced to remove your tiny home from the property entirely, on top of facing fines, permit denials, and losing your ability to sell or insure the structure at all. So layer 1 of our composite illegal tiny house is already in place before we've even discussed the land it's sitting on, a structure legally registered as a vehicle that hasn't moved in years, sitting on a permanent-looking foundation of skirting and hookups it was never supposed to have if it wanted to keep that classification. It's worth pointing out that classification confusion isn't a fringe issue affecting a handful of unlucky owners. Current tiny house law trackers describe the legal landscape as genuinely fractured state by state, with some states having no clear statewide framework at all, leaving the classification question entirely up to individual counties. Even the terminology itself has been shifting. A growing number of jurisdictions have started using the term movable tiny home as its own distinct legal category in 2026, separate from both traditional RVs and permanent dwellings, specifically because the RV classification was never a great fit for a structure someone is trying to live in full-time. Where that newer category exists, it genuinely helps. Where it doesn't, owners are still stuck navigating the same blurry, decades-old distinction between vehicle and dwelling that's caused most of these problems in the first place. Classification is only half of the equation. The other half is whether the specific piece of land this house sits on actually allows it to be there at all. And this is where things get genuinely regional and unpredictable. Zoning restrictions on tiny houses fall into a few consistent patterns across the country. Some cities effectively push tiny houses out of residential neighborhoods entirely by classifying anything on wheels as an RV, which then legally can't be used as a full-time residence outside a designated RV park. Meaning even a beautifully built, fully code-compliant tiny house can become illegal purely based on where it's parked. Other cities block tiny houses through accessory dwelling unit bans, closing off the backyard placement option that's become one of the most popular legal pathways for tiny house owners nationally. And some jurisdictions use buried minimum square footage requirements, sometimes as high as 1,000 square feet, that quietly make any genuinely tiny home illegal before construction even starts, regardless of how well it's built. The genuinely tricky part, according to current legal guides on this topic, is that a state can be broadly tiny house friendly, while individual cities and counties inside that state maintain their own much stricter rules, often buried deep in local ordinance books that were never designed to be easy for an ordinary buyer to find or understand. A tiny house owner can do everything right at the state level and still end up illegal the moment they cross into the wrong city limit. For our composite worst-case tiny house, Layer 2 stacks directly on top of Layer 1. It's not just misclassified, it's sitting on land zone in a way that wouldn't allow it, even if the classification were fixed. Now let's go inside the structure itself, because this is where our composite house picks up its most serious violations yet. We've covered on this channel before how an undisclosed second kitchen is one of the clearest legal red flags a residential inspector looks for, treated in cities from Bellevue to New York as direct physical evidence that a single-family structure may actually be functioning as an illegal, unpermitted second dwelling unit. Add that second kitchen to our composite house, unpermitted and hidden, and you stacked a third distinct category of violation on top of the classification and zoning problems already in place. Then there's the building code layer itself, separate from zoning entirely. Even where tiny houses are legally permitted to exist, they still have to meet actual construction standards, egress window sizing, minimum ceiling heights, structural requirements, and for foundation-built tiny homes, the specific provisions under Appendix Q that allow compact staircases and lofts that traditional code would otherwise forbid. A structure that skips these standards isn't just violating a zoning technicality. It's potentially unsafe in ways that matter in an actual emergency, which is exactly why building code violations, unlike zoning violations, tend to get treated as urgent rather than administrative once they're discovered. This distinction matters more than it might sound like at first. A zoning violation is fundamentally a question of permission. Is this structure allowed to be here, doing what it's doing? A building code violation is a question of safety. Can the people inside this structure actually get out if something goes wrong? Regulators consistently treat the second category with more urgency, because a structure that technically has permission to exist but was built without proper egress or structural standards can still genuinely hurt the people living inside it, permission or not. Our composite house, by this point, has accumulated violations in both categories simultaneously, which is precisely the combination that tends to move an enforcement case from a slow-moving paperwork dispute to something officials treat as needing immediate attention. I want to pause the composite for a moment, because everything in this video is built from documented, real enforcement patterns, not invented drama, and it's worth showing you two of them directly. In New Haven, Connecticut, a set of tiny structures built on a residential lot to house people who would otherwise have been sleeping outside became the subject of repeated formal violation notices from the city, specifically because the structures remain non-compliant with local zoning and building code requirements for what officially counts as a legal dwelling unit. City officials were direct about the tension involved, acknowledging they weren't trying to cause harm, while being legally required to report ongoing non-compliance as long as the structures remained standing, because enforcement in that case was treated as a matter of public safety obligation rather than discretion. On the other side of the world, in Cabarita, Australia, local council authorities have been actively ordering the removal of unauthorized tiny homes that had proliferated in the region, built specifically on wheels in many cases to try to sidestep permanent dwelling classification rules. The council's position has been consistent, regardless of the genuine housing affordability crisis driving people toward tiny houses in the first place. Structures that bypass safety and infrastructure requirements are being treated as unauthorized development subject to removal, not as an acceptable gray area workaround. Both of these cases show the same underlying pattern our composite house is built from. It's rarely one dramatic violation that triggers enforcement. It's an accumulation of smaller non-compliance issues, classification, zoning, construction standards, that eventually crosses a threshold where officials are obligated to act, often regardless of the very real and sympathetic circumstances of the people living in structure. When enforcement does happen, it tends to move faster and hit harder than most tiny house owners expect. Zoning guidance from this year is consistent on a range of consequences: forced removal of the structure from the property, financial fines, denial of future permit applications, and a lasting inability to sell or insure the property while it remains out of compliance. Meaning the financial damage often extends well beyond a single fine into the resale value and insurability of the home going forward. The uncomfortable reality is that none of these violations announce themselves in advance. A tiny house can sit for years without any issue, right up until a permit review on a neighboring property, a utility company flag, or a routine county assessment brings an inspector or code enforcement officer to the door, at which point every layer of noncompliance that's accumulated over that time becomes relevant all at once, not just the most recent one. The good news, genuinely, is that every single layer in our composite worst-case house has a straightforward fix, and none of them require abandoning the idea of tiny house living altogether. Start with classification. Know definitively whether your structure is titled as a vehicle or approved as real property on a foundation, and understand what behaviors, permanent hookups, extended immobility, permanent skirting, could put that classification at risk in your specific jurisdiction. Check your zoning at the most local level available, not just your state's general reputation. A state can be broadly tiny house friendly, while your specific county or city maintains restrictive rules that would make your planned placement illegal regardless of what the state allows. Confirm every room in your home matches what's actually permitted, especially kitchens, since a second kitchen is consistently one of the fastest ways a compliant single-unit structure gets legally reclassified into something requiring an entirely different permitting process. And build, or buy, to actual code, not just to a standard that looks similar. Appendix Q exists specifically to make compact, code-compliant tiny house construction legally achievable, which means there's rarely a good reason to cut corners on genuine safety standards just to save time or money during a build. So let's bring this back to where we started. A structure registered as a vehicle that never moves, sitting on land zoned for something else, built below legal size minimums, hiding a second kitchen nobody permitted, wired and plumbed without proper inspection. No single tiny house needs to carry all 5 of these violations to become a real, documented enforcement case. Real cases from New Haven to New South Wales show it usually only takes 2 or 3 before officials are legally obligated to act. The composite house in this video isn't a scare tactic. It's a checklist of exactly what not to accumulate, one overlooked rule at a time. If you want more of these, real enforcement cases, real regulations, no exaggeration, subscribe because the next video takes the opposite angle entirely. The single most over-permitted, over-inspected tiny house ever legally approved, and everything it had to prove to get there. Thanks for watching all the way through. I'll see you in the next one.